All right, I'm happy to bring in criminal defense attorney Michael Bixon here with me to break it all down. Michael, first of all, I think it's going to be a fiery trial because all of the attorneys that we've heard arguments from, in my opinion, are well prepared. They know the law. They know what their respective arguments are.
Oh, absolutely. I mean, if what we've seen so far from these motion hearings carries over into trial, I think it's going to be an excellent trial. I mean, you have great defense attorneys, you have great prosecutors handling both sides of this case. I think they're coming in very well prepared and equipped to handle a case of this magnitude. And I think it's a great thing because the last thing you want to see is a case that is as important as this sort of being mishandled. And I think it's being really well done so far.
Yeah, I agree with you completely. Now, let me ask you this, though, because the mental health of the victim in this case, Ahmaud Arbery, we know the defense is saying that he has a document, an evaluation that they want to come into evidence. The state's saying, why? It's not relevant. We don't understand the argument of defense to convince us that it's relevant. And the judge basically, as I understood it, Michael, said, all right, listen, you're going to put it in writing. You're going to submit a brief to me explaining defense why you believe it's relevant and admissible under the law. Do you think, as a criminal defense attorney, that it is relevant and potentially admissible or not?
Well, if I was the defense attorney in this case, I'd absolutely be arguing that it's admissible. Now, as an objection to the admissibility of it from the prosecutors, yeah, absolutely. I think they have a strong point to it. But for the defense attorneys, I can absolutely see why they're trying to introduce it because I think it's going to be a very important part of their defense for this case.
All right, so I'd like to listen to a little bit of argument that it would be reckless to disregard his mental health, but then I'm going to come back, Michael, and have you help me understand how it would actually be admissible.
The state is citing cases to you under the umbrella of relevance to say, well, there's a lot of cases where you can attack the credibility of the witness. We're not talking about that. We are so far moved past that issue. You're hearing it now from me. It's not about the credibility of Ahmaud Arbery. And it is okay to recognize and celebrate who Ahmaud Arbery was in 2012 when he graduated high school, but it is reckless to disregard the mental health illness that plagued him for 8 years leading up to this moment in February 23rd, 2020.
So, Michael, help us understand in terms of the defense argument saying, listen, it's reckless to disregard the victim's mental health. Why should it be considered when he is the victim in this case?
Well, even though he is the victim, there are certain circumstances where you can introduce facts about the victim, such as mental health or things like that, even though they might be considered, prejudicial. If you're talking about somebody's mental health state, and that goes towards things like, their plan or motive or intent or the actual acts themselves, there are times when it could possibly be admissible. Now, the way that the defense characterizes it, obviously, is a very defense-friendly argument, and I think it should be characterized as just that, argument. And coming from the defense, I'm not totally surprised by the way that they framed the issue, but still, I think the state still has some good arguments on their side to counter it.
And I respect the judge for saying, okay, I'm hearing all of this and I need the dots connected. That was my interpretation of what he was saying. And so, defense, I'm going to give you time, 20 or 30 days, depending on which respective motion they're discussing, to put it in a brief and give me all of the elements and arguments, and then state you have time to respond to that as to why you do not think it's admissible. In your practice, Michael, is it something that you see or are told by courts, okay, I'm going to take it under advisement, but you're going to brief the issue and give it to me so that we can make a decision?
I've seen it happen plenty of times, especially when it's much more serious and it's sort of a central part of the case. The judge is really going to want to sit down and not just hear oral arguments from, the different attorneys in the courtroom, but have something laid out in front of him that he can sort of read, analyze, and research on his own and give time to really, consider the issue at hand. I think it's the right call in this case.
Yeah, and as a judge, I'm going to be the first to tell you, I will break out the code book while I'm on the bench or have attorneys brief it because we don't know everything. We have to be educated about the exact argument that you are making on behalf of a client or on behalf of the state. I'd like to listen to a little bit more of the argument about the inadmissibility of the mental health evaluation that was done on the victim.
So the protection is, we are going to protect people's rights to communicate openly and freely about their problems. But that doesn't mean we can't learn what was decided and determined based on those communications and what diagnosis came and then how it impacts the person. I'm just speaking right now to the statement by the state that pursuant to 24.5501, pursuant to 24.4411, that psychological records are inadmissible. That is a fundamental misstatement of the way our courts have interpreted the privilege in line with the Sixth Amendment of the Constitution and a defendant's right to confront. Yes, there's a privilege, but that analysis and interpretation flies in the face of all of the cases that say you can have access.
And so just to clarify, that defense attorney is saying it does not mean that it's inadmissible strictly because it's a mental health evaluation. And I want to point out and ask you about this. I understand that Gateway, the facility over who did the mental health evaluation, had filed a motion to quash subpoena, and I believe there were appropriate releases that were videoed, so they then withdrew their motion to quash. So we know the subpoena's out there for the medical records. That's hurdle number one, right? We got rid of the motion to quash the subpoena, and the subpoena exists, and now we have this evidence. Does it get to come in or not? What is the balancing act that the court has to engage in to make a decision ultimately as to whether or not his mental health evaluation comes into evidence?
Generally, for something like this, the main test that you're going to look to is whether or not is it overly prejudicial. And you look to a number of different factors for that. I think that the way the defense was framing it, though, in terms of almost bifurcating out, take out the statements, but we really are more interested in terms of the diagnoses. I think that's sort of the right way to look at it. In terms of how the judge is going to look at it and make an actual determination as to what he's going to let in, though, I'm leaning towards it's definitely possible that they're going to get that in. Maybe not the specific statements or whatever was made by Mr. Arbery, but at least maybe in terms of the diagnoses.
So I wrote down yesterday, I took copious notes because it's what I tend to do, and I wrote down what I understood the defense argument about why this evaluation is relevant and should be admitted. And part of what I understood them to say, Michael, was self-defense. That's part of their defense. Number one, they were making a citizen's arrest, and number two, they acted in self-defense. And that in considering self-defense, one must consider fear by a reasonable person and whether that fear existed. And that in considering that fear, there should also be the ability to present evidence about the person and whether or not it would be a reasonable fear. Does that all make sense to you? Do you think that's, and I may have gotten it wrong, so jump in and tell me your thoughts about that.
So when you look at it in terms, and I think the state had a very good argument about this, and you heard them talk about how would the McMichaels know what Arbery's state of mind was? How could they reasonably be afraid when they had no idea who he was or what he was thinking? They had no idea about his past or anything like that. I think the state had a very good argument about that. In terms of whether or not, the defense is going to get something in because of that reason, I think it's certainly going to be a stretch because I think the prosecution does make a good point about just that.
Yeah, again, I agree with you. These attorneys are prepared and ready and have law to back them up and are arguing their client's position. So I know that there's been some chatter about frustration about why are we even talking about this, but at the end of the day, that's the point of pretrial motions, to see what arguments you're going to make and what the judge is going to allow you to present and not present. Michael, I know you're going to stay with me. We're going to continue to break down the arguments around should the victim's mental health evaluation be admitted into evidence or not. Stay tuned here on Court TV Live, your front row seat to justice.
We've been friends for 7 years. I'm not that skilled in the world of cooking.
Today, you are going to become a cook.
So how do we do it?
Let's just follow the directions.
Not only do they give you the ingredients, tell you how to make it, but they portion everything out.
It's taking out all the stress of it. Do this move, it kind of looks like you know what you're doing. It's like a life hack.
I can't believe we made it.
It's really good.
Every night, cooking.
That's a new you.
Yeah, I'm getting a little pep in my step.
Yeah.
Go to HelloFresh.com and use code TV12 for up to 12 free meals.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott, honored to be with you. We are breaking down the motions, hearings, and what the judge listened to. We are talking about the mental health of the victim in this case, Ahmaud Arbery. The defense continued its argument, and during the argument of the motion, defense attorney Jason Sheffield even brought up the factors of drugs and alcohol.
There are several cases, Your Honor, under Georgia law that deal with the impact of alcohol and drugs on a person's mental state and how it causes behavior. Very simply. Is there something going on in the system of the person that causes them to think and do and act in ways that's relevant to the determination of the issue? Crow versus the state is 277 Georgia, 513. It's a Supreme Court case from 2004. And Crow says there was an expert in that case where the defendant driver got into a car accident with a woman. That woman was under the influence of drugs. And the defense offered it to try to suggest that the victim driver was under the influence of drugs, that it affected her conduct and behavior and her decision-making. Whether she braked before the accident, whether she could have turned, did she act and behave in a way that was reckless on her part? And the court said it is for the jury to decide. The jury is entitled to hear all the relevant evidence, judging the credibility of the opposing witnesses, and make the decision for itself. So it begins to speak about, this is something that if we present to you that there is a relevant purpose, then that brings it now to the purview of the jury.
All right, so Michael, I understand the 405 argument. So what is a 405 argument talking about? Character of a person can be shown by evidence of reputation and opinion. But help me lay out, a mental health evaluation is not that under 405, correct?
Correct, yeah. And I think they are trying to stretch this argument into the 405. I personally don't think it really deals so much with 405 as it does things like 404 and 403. And, you know, for people who aren't familiar with all the many different various sections of the Georgia Code, we have different code sections that cover everything from relevancy to things like character witness information. And I think that this more so goes towards 403 or maybe even 404 than 405 personally.
And what are 404 and 403 for our viewers? Let's see, the 403 is the probative value cannot be outweighed by or substantially outweighed by unfair prejudice, right? So that's something the court
Correct.
has to consider. And then remind me what 404 is. I have to sometimes keep a cheat sheet because I always reference these things.
So 404 deals with if you're going to try to introduce either specific acts or traits of a victim or, you know, of a defendant, in this case, obviously the victim. And courts are very picky about how they let things like that in. If you're going to be addressing things like mental health or anything like that, there's a lot of different tests that you're going to have to pass in order to get this admissible to a jury and for them to actually be able to hear it.
That's right. It's not prior acts, prior crimes are not admissible to show the character of the person, but for other reasons. Thank you, Michael, for that. I want to listen now to what the judge had to say about listening to these arguments about the mental health, admissible or not. Here was his conclusion.
I would not be comfortable presenting that type of evidence to a jury without a limited instruction.
I understand.
Okay? So that limited instruction, I guess, is one. Two, I just want to make sure that I'm clear, because I realize your argument, but I'm looking at both of you. I don't see how this issue gets the jury without the state getting up and trying to counter that evidence. So I end up with a mini trial on the mental health issues that we're talking about here. Is there any way to avoid that?
Well, if the state chooses to counter the opinion, the court would first have to find that the mental illness has a relevancy. The court doesn't have to agree whether, but the state would have the right. Yeah.
7403, I've got to work through 403.
Right.
So another thing I've got to work into this is what this little mini trial is going to look like in front of the jury, a battle of experts over whatever this mental health diagnosis was in 2018, what that meant in 2020. And I'm going to have a battle of experts as far as I can tell, and you'll tell me if I'm going down the wrong path here, but I'm going to have a battle of experts in front of the jury in a murder trial about what the mental health records of the victim meant.
The state would have the right to counter our presentation, certainly, Judge. I would think they would. If they found that it was flawed and that it has no bearing on February 23rd, 2020, and they wanted to put up an expert to rebut that, I think they would have the right in the law to do that. Your Honor, it is easy and it is reasonable to say that this is an issue that could become a mini trial. But I think that often carries with it the idea that that's a negative thing that we should try to prevent from happening. We're not saying we want to inject a mini trial of another matter in this case. We're saying that it holds a special significance to the case.
And the judge gets it. It ends up, Michael, being somewhat of a mini trial so the judge can rule and make the decisions. There's been a lot of talk about that. Some people feel defense attorneys make these kinds of motions, especially in a high media case like this one, to get the information out to potential jury pool about the victim's past or the victim's mental health. Is that the case in your opinion?
I don't think so. And correct me if I'm wrong, are you trying to state that the defense is trying to get this information out just to sort of throw at the jury, or are you saying in terms of actually to be able to use it during trial?
Well, no, first I'm talking about to get it out there to the general population so that it taints the jury pool, so to speak, and they have this preconceived notion about the victim being at fault.
That's certainly a possibility. I think it's more of a stretch, though, because, on a case like this, you're going to have so much voir dire to go through. And I think that if it's done right, at least, I don't think it's going to be an issue in terms of tainting the jurors. I think that it really does go more towards the, actual issues in this case, the self-defense, obviously, the victim's character. I think that at least from a defense perspective, that it is going to be more probative. So, I don't think it's going so much towards just to sort of throw out there towards the general public and sort of taint the case. I actually do think that it is going to be used very well in this case.
So in the last 30 seconds, Michael, give us insight into your cases when you're a criminal defense attorney and it's expected to go to trial. Do you file a lot of motions?
It really depends on the case. You don't want to just try to throw out 1,000 motions that really don't carry any weight. You're just going to end up with a very upset judge. I try to file motions when they're necessary, when they're due, and when they really need to be filed in order to protect my client's rights. But overall, I don't try to file just 1,000 motions just to have 1,000 motions in there.
All right, great insight and great advice, right thing to do. You're going to stay with us. We are going to need to take a break, but you're not going to want to miss as we continue to break down everything that has happened during these motions hearings and where does this leave us before proceeding to trial against 3 defendants. We're going to break that down as well here on Court TV Live, your front row seat to justice. Welcome back to Court TV Live this Thursday afternoon. I'm Judge Ashley Wilcott with you. We have some breaking news in the trial of the 3 other officers involved in the death of George Floyd. Judge Peter Cahill postponed the trial of the former officers. The 3 of them are Thomas Lane, J. Alexander King, and Tu Tao until March of 2022. Now, the ex-cops were originally scheduled to face trial on August 23rd. Judge Peter Cahill said he changed the date so that the federal case can go first. During the motions hearing today for King, Lane, and Tao, the court also focused its attention on two other motions. Thomas Lane, motion to compel discovery, and Tao, motion to dismiss this or sanction the prosecution. Court TV legal correspondent Shanley Painter was inside the courtroom for the hearing. She joins me now from outside the Hennepin County Courthouse. Shanley, always great to see you. Huge news that this is being delayed.
It really is. This was the final fact that the judge took up this morning. Judge Peter Cahill, the same judge we witnessed in the Derek Chauvin trial just a few weeks ago here at the same courthouse, and we were in the same courtroom as the Derek Chauvin trial. He decided that on his own motion, sua sponte, that he was going to move or continue the trial date of the three other former officers, Tao, Lane, and King, from August 23rd to March 7th and 8th. So March 7th will be a motions day, much like we saw in the Derek Chauvin trial, and then March 8th, that is when jury selection will begin in the joint trial of those other three officers. He reasoned that it would make sense to wait until the trial in federal court comes to fruition. He said, we'll wait on that to be handled first. That may affect the state charges, is what he said. He also wanted to put some space between this massive pretrial publicity that is garnered in this case from the Derek Chauvin trial and the verdict in that case, also pending sentencing coming up in the month of June for him. So he wants to put some space to hopefully not be so much in the news, I guess is what you could say, and to impanel this fair and impartial juror in March.
So it does make sense to put space in between that verdict and the trial for these to ensure a fair trial. But Shanley, one of the questions I have is the fact that we don't have a federal date at this point in time on the federal charges, right? There's no court date set. So I understand he's moving it out, but I want to make sure I don't misunderstand. It doesn't mean that the federal case has set a date.
You are correct. Very astute, Judge Ashley. There is no date yet set, which could mean that the trial here at the state level for these former officers could even be continued again, depending on Judge Cahill and what he believes. But he did say in his reasoning that the federal case and the charges that they're facing, the other three officers, would face harsher penalties in federal court. And he opined that that could possibly combine or take care of even these state charges if they are sentenced and convicted, first of all, in federal court, and then sentenced on those charges that they do face, which what they are charged with in federal court could be a term of years up to life incarcerated for what they're facing there in federal court.
And, you know, it's probably no surprise. A lot of attorneys probably are not surprised to hear that the federal case would go first. How did all of the attorneys for each of these three defendants respond to that? Was there any jumping up and yelling and saying, no, we want a right to a speedy trial, we want to go now? Or did they act as if they expected this?
They acted as if they expected it. In fact, Judge Cahill was pretty candid. He said that we talked yesterday off the record. There seems to be a lot of that in this case, Judge Ashley, and he wanted to put on the record today that they had discussed this and that all three defense attorneys for Lane, King, and Tao agree with this motion to continue, if you will, from Judge Cahill. However, Matthew Frank, the Assistant Attorney General here for the state of Minnesota, did put on the record that his office objected to the continuance. They're ready to go to trial, he said, but he understands the judge's reasoning.
And I understand there were some other motions. I mentioned those and I got caught up because I didn't realize until I thought about it that Tao had a motion to dismiss or to sanction the prosecution. So tell us about all the different motions.
Yes, the court heard two motions that have been pending for several months in this case, and the one, like you said, former officer Tu Tao's motion for sanctions due to prosecutorial misconduct, and it deals with the leak that Derek Chauvin was willing to plead to third-degree murder just days after the death of George Floyd last May, and he was going to agree to 10 years for third-degree murder, and that plea deal was quashed by the then U.S. Attorney General William Barr. So that leaked in February, right before the trial of Derek Chauvin. And so former Officer Tao wants to put this motion forward to say that's prejudicial, would affect a jury pool. And Matthew Frank today countered, arguing that his office is not the leak. to that news, and that he doesn't control any other law enforcement type sources like the BCA, the FBI, the DOJ, if that in fact is where that information did originate from. And the judge took up this, both sides, and he actually ruled that there will be a hearing on this. He's going to grant the defense's request, and I should mention that all three defendants joined together in Tal's motion here, that he's going to grant an evidentiary hearing on this matter. He said that he suggests that the prosecutors involved in this case from both the AG office and the county prosecutor's office file affidavits, sworn affidavits, saying that they are not the source of this leak. Otherwise, he believes that the defense will subpoena all the prosecutors that have worked on this case in the offices to this evidentiary hearing, put them on the stand, ask them if they are the source of this leak, because the judge took this very serious, Judge Ashley. He actually said this is a pernicious issue. This goes directly to these defendants' right to a fair trial. It was also interesting that Matthew Frank argued that this didn't taint the jury pool for Derek Chauvin. In fact, they were able to impanel a fair and impartial jury.
You know, what's interesting to me is that denotes the fact that he's going to have a full evidentiary hearing denotes that, gosh forbid, there's any type of evidence that this actually came from the prosecutor's office. I'm not saying it did, but if there is evidence, that he would seriously take into consideration dismissing charges. And if all three joined, potentially this could be a dismissal as to all three.
You are correct. That's what he said today in court when I was in there. He said it would warrant sanctions and dismissal of charges. But he also indicated, he really echoed what Matthew Frank said, that they believe the source of this leak stemmed from the Department of Justice. Just because, to use Judge Cahill's words this morning, it's what was released or leaked is insider baseball. It was about the federal level charges that, Derek Chauvin was willing to agree to serve time in federal prison, that it was William Barr who quashed this deal, and they just believe that it's probably at the DOJ level.
All right. Very interesting. Well, stay tuned for that. Now, I also understand, Chanley, there was a motion to compel discovery filed by defendant Lane.
This is an interesting motion, and his attorney Earl Gray argued it this morning. Now, the motion that he filed, Judge Ashley, was asking for all unauthorized use of force incident reports in the last 50 years. Well, today he amended that to 30 years, and he wants these complaints from the MPD Internal Affairs Office. He argued that this was necessary for him to be able to impeach the witnesses for the prosecution and use of force experts if, in fact, there are no prior incidents of an officer following policy, which is to intervene when they see a senior officer using excessive use of force. So the state responded that Officer Lane, he was a rookie. Yes, he was on day 4 of his job, but he was trained under this policy. In fact, the very fact that he, in the incident, told Derek Chauvin, his senior officer, that we should maybe turn him on his side shows that he knew that this was policy and something that he should do. Ultimately, the judge took it all under advisement. He actually requested that the prosecution seek to find out how burdensome it may be to work with the internal affairs of the Minneapolis Police Department to only pull about 5 to 10 years of reports for the defense, because he's saying this wasn't written policy of the department until 2016, so it may not be relevant until it was actually written policy, not the last 30 years. And there's more of a story to why he was asking for 30 years, and that stems from one of the key witnesses in the case against Derek Chauvin, Lieutenant Zimmerman, the longest serving MPD officer, most senior officer who testified against Chauvin. Not in the trial, but in a different interview. He talked about 30 years ago when he was an officer that his senior partner on the job actually started kicking one of his suspects, and he intervened. So somehow the defense wants to impeach him in his story if he testifies.
Well, it's going to be interesting to see. I think that you split the baby in the bathwater, so to speak, if you do the 10 years, because it still requires, that could take a lot of work to pull 10 years worth of records from internal affairs about complaints of any wrong use of force. There may not be many. You don't know until you start the process, but not every state and every county and every city has it well organized on computers to hit a button and print it out. So, that may be burdensome. I know the judge is taking it under advisement. We're certainly going to wait to see what the judge decides about that. But I also think when you hear all of this, this is, from my perspective, and I love that you're there, can give us the color of the courtroom. I mean, these are some major developments for these three defendants in these charges that they face.
Huge developments. First of all, the trial is delayed. The judge is also continuing, he said, to deny a change of venue. He gave the attorneys plenty of homework, Judge Ashley, to go back and work on, including juror questionnaires, as well as a scheduling order now with this new trial date. And I'm glad that you mentioned inside the courtroom, because I'm in there. I'm in, for reference for our viewers, I was sitting in juror number 3's seat inside the same Derek Chauvin trial courtroom, along with about 13 other media from all over. And it was a great seat to be in. Juror number 3 had a great perspective and eye line to the witness box, the judge, and direct to the defendant, Derek Chauvin, throughout the trial. It was neat to be able to sit there. And I have to also mention that these three defense attorneys, it was quite acrimonious between the defense attorneys and the prosecutors. Very different from what I witnessed inside the courtroom during the Derek Chauvin trial between Eric Nelson and the prosecutors. They were quite cordial, seemed to get along, but not with this team.
Wow, interesting. So it may be a fiery trial in that case as well. We'll stay tuned. Thank you so much, as always, Chanley, for being there live on the ground and giving us all the latest breaking news in the death of George Floyd and the three co-defendants. We're going to pivot now and talk about Greg and Travis McMichael and William Roddy Bryan. These are the three defendants who appeared in court today for day 2 of a motions hearing in the killing of Ahmaud Arbery in South Georgia. All three men are charged with chasing Arbery and fatally shooting him. Travis McMichael says he shot him in self-defense. During the motions hearing today, the defense argued excluding jailhouse calls made by the defendants. Court TV anchor Ted Rowlands has more on these calls.
I have been filleted and laid out as a sacrificial lamb. It's all political.
That is Greg McMichael talking to his brother on a recorded jailhouse call.
This narrative that we just shot a black kid for running through a white neighborhood is absolutely.
Defense attorneys want all of Greg and Travis McMichael's jailhouse conversations with family and friends excluded from trial, saying it would violate their due process rights.
You've heard the old saying, no good deed goes unpunished.
Yeah.
Well,
yeah, that's it. That's a shining example right there.
That's right.
The defense says prosecutors will argue the good deed Greg McMichael had in mind was the killing of Ahmaud Arbery. But in a motion, they contend what Greg actually had in mind was the, quote, attempt to conduct a private person's arrest of Arbery, so police could investigate whether Arbery was responsible for a string of neighborhood burglaries. In a later call to his wife, Greg McMichael gets angry discussing his daughter's social media post, which showed a photo of Ahmaud Arbery's dead body.
She has got to stop.
She will.
Can get rid of that stuff.
Yeah.
Make it disappear. Make it go away. Because people are accessing it. If not, it's liable to really screw us up.
That phone call was brought up by the prosecution at the McMichael's bond hearing.
We had talked about the social media post by your daughter, Lindsay. That post was actually made with a picture of the crime scene while she was under your roof. Is that accurate?
That's accurate.
Okay. This becomes significant because of some of the cross-examination of Lee McMichael regarding jail calls that are captured regarding Greg McMichael actively attempting to obstruct the investigation of this case.
Many of the phone calls that Travis McMichael makes in jail are to his friend Zach, who also testified on the McMichael's behalf during the bond hearing.
Are y'all close? You and Travis?
Yes, sir. Oh, yeah.
Okay. How close would you say that you are?
He's my best friend.
On the phone, Travis tells his friend what matters most to him.
So I'm just praying that I get a bond, where I can get out of here and raise my boy and really be able to put the nose to the grindstone.
Travis and his mother talk about how big the case has become and what lies ahead.
This is going to be a trial with the TV station, with O.J., like an O.J. Simpson trial.
Oh, my God.
But that's a good thing because they're going to see facts that's not there, that they haven't seen.
What it boils down to is 12 people going to decide what's what.
Right, exactly.
It'll be a long process, though.
All right, I'd like to bring in my guests. I have two of them here with me to break this down. Criminal defense attorneys Michael Bixon and Sudi Chada Jimenez. Thank you both for being with me. Sudi, I'd love to start with you. Generally, jailhouse conversations, the right to privacy, I think many know and argue, goes out the window because they know it's being recorded. It's policy, it's being recorded. They're told it's being recorded. Is that correct or incorrect from your perspective as a defense attorney?
It is absolutely correct. I mean, like I'm sure Mr. Bixon would say, the first thing we tell clients is just don't talk on the phone. You can tell your family members, I love you, I miss you, how's the weather, how's your birthday party? Do not talk about the case. Just don't. The only person you talk about the case to is me, your attorney, because there's a privilege there, attorney-client privilege that cannot be waived. So anything you say on the phone can and will be used against you. And what's even worse, it'll be used against you out of context. And then you're going to put in a position where now you have to explain your own words. So sure, maybe when you're saying, no good deed goes unpunished, it's because you were trying to be the cop of the neighborhood. So now you're going to have to take this stand, but that's by your own doing. So that's whatever you say on the jail calls is coming in.
And that's what's really hard. You're right. If they want to explain it away, then they have to take the stand. But the attorney might be saying, you don't want to take the stand. We're not going to do that in this particular case. That's my advice to you. Michael, what about the privilege? So we know when we just listened to testimony about conversations between Greg, he's the father, and his wife, Lee. Are those protected by spousal privilege, do you think?
No. I mean, generally, everything that's over the phone, even to like your lawyer, they can use against you in court. And most people don't even realize that. Even your lawyer, if they call me, I don't want to talk about the facts of the case because it can still be recorded and used against you. So almost anyone, I mean, it's a very, very dangerous thing to start talking on the phone about anything relating to the case because it will be used against you. And as we just heard, out of context even.
And what then, Sudi, if I could just ask, why are these motions being made? Let me rephrase that. Is it surprising to you that the defense is making these motions to exclude the jailhouse conversations?
Absolutely. I was actually very surprised, and I know those attorneys very well. I've been trained by them, actually. I've been trained by everybody that's in that courtroom on both sides of the bench. And I don't know exactly where they're going at when they're challenging the jail calls admissibility. I understand when you want to challenge it because there might be tampering, there might be incompetence on the part of the sheriff's department or whoever's managing it that are just not recording it properly. They're getting cut off, they're choppy, they only have one part of the conversation, but they lost the other part of the conversation because then rule of completeness comes in. I want to listen to the entire 30 or 15-minute call as opposed to this little tiny snippet, and that's the only thing you gave me. I see that as challenging whether or not calls should be used against a person. I mean, we have a lot of exceptions. They're just statements by party opponent. That comes in. When it comes to privilege, just like the Bixon just said, even if you're talking to me, your attorney, which is the strongest privilege that I can think of when it comes to the court of law, if it's on their phone, on the jail call, who's telling you someone else is listening, the moment you bring in a third party, that privilege has been waived. If you're talking to your wife in the privacy of your own home and no one else is there, sure, you might have a privilege there. But the moment you invite the neighbors, hey, come on, sit over here and let me tell my wife about everything that I've done, you just waive the privilege because you're sharing it with the world, and that jail call is being shared with the sheriff's department. So you waived whatever privilege you claim there is. So I have no idea other than to upset the judge. I mean, the judge did not seem very happy with this motion today.
Well, it is interesting. They did file a number of motions, but let's listen to a little bit of the testimony that was offered specifically about the jailhouse calls. All right, so I'm sorry, I misunderstood. We don't have those available right now. Instead, we are going to take this opportunity to take a short break here on Court TV Live. Don't go anywhere. We will continue to break it down and cover all the motions presented in court. I'll be right back on the other side.